Good morning. Our next case is Cummings versus Summa Health Systems et al. As you are getting settled, each party will have 15 minutes to present their argument. The couple may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
4 minutes, please, Your Honor.
Very good, thank you. The court will note that. And we will be keeping the time up here, and you can see it's off there to your right, I guess. I'm not sure that's any what direction it is to you folks. They say that. At any rate, I will try to let you know in about a minute left. When you're going first, keep track of that initial time. When it's down to 4 minutes is when you should stop. So please ignore the rebuttal time at the bottom. We're not keeping track of that. The arguments are being recorded, so when you're before the podium, just stay in front of the podium. Make sure you introduce yourself before you start for the record. Stay behind the podium and speak with loud voice. We are visually recording you, so if you move, we'll lose the visual and likely the audio recording, so we can stay back there. I don't know that it really applies in this case. If you're referring to a child, minor, or victim during your argument, you can refer them by initials or some other designation, like in this case, patient C, rather than the name of that individual. Having said that, we read your brief, and are ready to proceed whenever you are.
May it please the court. Good morning, Your Honors. My name is Mike Rudinger. I represent the Summa defendants in this interlocutory appeal from a trial court's discovery order. As Your Honors know from the briefs, this is a case with troubling facts involving a discrepancy in misdiagnosis. No one disputes that, and I understand plaintiff's desire to seek answers into how that happened. But the trial court's order goes too far by compelling Summa to dig for those answers in a non-party's medical record. That patient, who, as Your Honor noted, the parties refer to as patient C, owns the privilege, not Summa.
Can I stop you right from the beginning? You said the trial court's gone too far. How is a plaintiff in this situation ever going to prove that there was negligence involved? Is it just a matter of it is because it is? I mean, I don't think you're admitting there's negligence per se, right? Absolutely.
I'm not admitting negligence per se, Your Honor, but when you look at the elements that are underlying this case, the actual discovery requests that were served on Summa respecting the patient C's potential biopsy tissue with the grossing, embedding, and cutting of that don't necessarily go to the underlying elements of the negligence claim that are brought by plaintiffs here. The claim isn't necessarily dependent on.
Well, what if there was an email or a document that says, uh-oh, we mixed up results, and it was this patient's and this patient's? Wouldn't that be the smoking gun here?
Yes, Your Honor, but there's a distinction between serving a discovery request that would involve a sort of corporate bad document like that and serving a discovery request that asks a hospital to extract responsive information from a particular non-party patient's medical record.
Summa is not giving anything that has the patient's name on it at all, right? Not a redaction or a...
No, that's correct, Your Honor, but the patient's, not in this case, non-party patient's name is not the only privileged aspect of a medical record. And that's the core legal...
So if that document exists, you're saying it's not discoverable in any form?
The particular requests that were served in this case, which requested information involving the where, when, what, and why of the handling of patient C's tissue sample is not discoverable in this case.
Are they asking for the why in this case? I understood you're objecting to the kind of the date, time, and who did the procedure, and not why it was done. Is there also why as part of your objections?
I think the why is subsumed within the where, what, and when. If you have the answers to those three, it becomes relatively clear what this tissue sample was being handled for and what the purpose
Well,
for
it's
that
already
was.
been admitted. It was admitted that this patient C had lung cancer. So why does that have any relevance? Everybody knows the cat's out of the bag.
Ultimately, the diagnosis of patient C in the records is not the issue that Summa is attempting to assert the privilege to protect here. This goes to the need to protect non-parties' medical records as a whole under the broad definition given to communications by this court in the Grove case and under 2317.02b5a.
I understand that. I guess I was responding to you when you answered Judge Stevenson's question and said the why is subsumed and it goes to why the biopsy is being performed. And I said we all know why the biopsy is being performed, so that doesn't really matter.
That's correct in this case, but as a general principle, I wouldn't say that applies in every case. As a typical rule, if you're given the where, what, and when information, you can extract the why. In this case, we know that's the case. But as a rule, when you're assessing whether there's a privilege attached to information extracted from a medical record, I think that's relevant to consider for other instances where, in this case, we know that. And really, the reason why that's in the record ultimately comes through the hard facts and procedural history of this case. The questions of law in this case are a little more straightforward and relate to, one, the interpretation of communication under 2317.02b5a, and two, whether there's an exception to the privilege. So I want to start with the statute itself and the interpretation of communication, because what the trial court got wrong here was focusing on the need for a patient-physician correspondence. And ultimately, the trial court doesn't address the second sentence of that privilege definition of communication in the statute, where the court says it's not just a communication that's externally transmitted. It can be a medical record, it can be charts, laboratory tests, it can be, and this is a crucial one, financial statements. No, this case does not involve a financial statement, but the fact that the statute in the General Assembly, when it defined communication, defined it that broadly, shows just because information is contained in the medical record doesn't necessarily mean, that's not the dispositive issue here. It doesn't always have to be, this was something that was essential to the patient's underlying treatment. If it can be something as far removed from the actual treatment process as a financial statement.
The language doesn't indicate it has to be necessary for the treatment diagnosis or similar to that, indicate it has to have some reference to the treatment of what's going on, and how is the date or time of the person who did the test necessary to tell us what the treatment is.
So there's two questions subsumed in that. Let me try to answer both of them. The first one, you're right that I think even financial statements, when you talk about procedure coding and things like that, have some sort of connection to the patient's treatment. So how does the where, what, and when of a patient's tissue handling connect to their treatment? It is, if you look at how the Ohio Supreme Court defined medical record in Griffith, which is I think where you get the language of it has to be something that was recorded in the process of a patient's medical treatment. Ultimately, the where, what, and when of a tissue sampling handling is information that a hospital is recording and maintaining in the process of that patient's treatment. So it does meet the medical record definition as discussed by the Ohio Supreme Court in the Griffith case. Now, ultimately, I think it's important to stress the most similar case here is this court's precedent in the Grove case. And the Grove case is noteworthy, not only because I know that Appalachian Council has focused on the Supreme Court's Roe decision, which isn't frankly entirely germane. It might be the highest court's decision on medical records we have, but Grove is a little more dialed in. Because in Grove, this court addressed a trial court's order requiring disclosure of information extracted from a medical record, like here, even after it had determined that the record itself was privileged. So that idea of can you take something out of the record, put it into a discovery response, and does it maintain the privilege when you put it in that context?
That starts with the premise that the court has decided that something is privileged and confidential. What the argument here is it is confidential. Is what time, date, and the person who did this, is that confidential or not?
Well, so in Grove, the court started with the premise that the medical record itself is confidential. To be clear, it is our premise that Summa has shown at the trial court level that the time, date, the where, when, and what of this procedure was part of the medical record.
Is it your position that all medical records are automatically confidential under 2317?
It's not a position we've staked as broadly as that in this appeal. I think consistent with, I mentioned Roe before, our position would be that if there is a medical record at issue, it is presumptively confidential under Roe unless an exception were to apply. And I understand that athletes here are arguing for a time, date, and manner. I'm going to use
Isn't that kind of turning around what I understand the privilege rule to be, that if you're arguing something privileged, the burden is on you to show it's privilege, not that we assume it's privilege to start.
It is.
You be the person showing privilege.
It is absolutely Summa's, we own the burden here to show, at least a prima facie showing of privilege under 2317.02b5a. We believe that Summa did that when it introduced at the trial court level the testimony of Robert Stewart. This was record 217 attached to Summa defendant's reply brief on their cross motion for protective order, where Mr. Stewart addressed the exact information that plaintiffs tried to seek in this case, testified that that is contained in the Vantage software system and Summa's laboratory information system, both of which he testified are part of the medical record. We believe that once Summa established that those were part of the medical record, that they were attempting to seek in written discovery.
So again,
that was,
you're back to saying to me, because it's in the record, it must be privileged. It is at the stand and you're asking us to know.
I think at that point it requires plaintiff to show that either there is not, something privileged about that, or that there is an exception that applied. And in this case, yeah, I think it's fair to say that because it is in the record and it meets the definitions of medical record, being something that was generated or maintained in the course of treatment, that yes, that's sufficient to make the showing of privilege, and you have to look to whether an exception applies. Now, I know they focus on this time, date exception. That's not an exception that this court has ever addressed. It's not a statutory exception, and when this court addressed exceptions to the privilege in Grove, it laid forth the statutory exceptions.
You have about a minute left. I don't like to call that an exception so much. I think courts have interpreted that as when you're looking at date and time, that's not privilege. It's not going under whether this exception, it's saying it's not privilege under 2317 to start with.
So the only courts that have truly addressed that argument, and I know they cited the Loparo decision out of the 8th District that's about a year old on this, have looked at it in a different context. And I think maybe this gets to the core of your question, Judge Stevenson. Those requests, if you look at Loparo, if you look at the Camacho case that they provided as supplemental authority, they are requesting facility-level aggregate data, something along the lines of, discovery request, and they said, tell us when this histologist's shifts were, where he was at these times. The key difference is if you serve that discovery request, you are asking about information about an employee that's not contained from somebody's medical record. There's a difference between asking for that aggregate level data and asking, give me something that is in patient C's file. With that, Your Honor, I understand my time is expiring. I'll speak to you again on the rebuttal. Thank you.
Please the court. Counsel, Attorney Megan Franz Oldham, my colleague Lee Placus, on behalf of the appellee Mariann Cummings and her family. At issue is whether Summa is permitted to hide behind doctor-patient privilege in attempts to hide dangerously sloppy laboratory work. The purpose of the justice system is to seek the truth. The search involves how, when. Summa is doing the opposite in this case. They are saying they were not negligent in this case. And in the same breath, they are using doctor-patient privilege as a shield to prevent Mariann Cummings and her family from finding out the cause of the contamination. Judge Carr asked a very poignant question, how is the appellee supposed to prove their case? You're not admitting negligence, you're not admitting that this is res ipsa loquitur. Summa is not. Summa has taken the position that contamination does not equal negligence. They have taken the position that sometimes contamination just happens through no fault.
Well, we're not here to decide that today. We're here on a specific question of whether this evidence is admissible or discoverable or not. So we're not deciding the big picture here. The question is this privileged or not? So can we focus on that question rather than the argument you want to make?
And the specific information at issue is barcode information. It deals with this vantage or soft information. And it deals with when a specimen comes to the laboratory, it is accessioned, it's given a barcode, and as it goes through the laboratory, it is read, the barcode, just like you do the grocery store, it is barcoded every step of the way by the person who's doing that. So that information should tell us specifically when the specimen was grossed by the pathology assistant, in this case John Coombs, when it was embedded by the histology technician, and when it was cut by the histology technician.
And you also want to know the person who did that, embedding and grossing, is that correct as well?
Correct. And while Summa refused to tell us who grossed patient C's specimen, we know from another defendant, Summa Pathology, they told us through request for admissions, they admitted that the same person, John Coons, grossed both specimens on the same day. But yes, Your Honor, we're asking for that information because Summa's saying we didn't cause any negligence. We're now taking the position of doing our own investigation to figure out where the contamination happened. Early in the investigation, through deposition, we asked Lorinda Kress, who's the manager of histology and morgue, we asked her, did you do anything as it relates to Mariann Cummings' contamination? And she testified that she was asked, very soon after they discovered the contamination, she was asked to find patient C and Mariann Cummings' times when they were gross, embedded, and cut. And I asked, when Mr. Stewart asked you to pull up that information, had you participated in peer review? She said, no, not at that point in time. I said, did you determine whether or not those specimens, when they were gross, embedded, and cut? And she said, yes, it's easy, it's through the barcode system. She said it took her roughly 10 minutes to find out. And I said, did you provide that information to Mr. Stewart? She said, yes. And I asked her, were they gross? Were patient C and Mariann Cummings, were their specimens grossed around the same time? And her attorney instructed her not to answer at that point under the objection of peer review privilege.
But this order is much broader than that. It's allowing all the patient information to be turned over, correct?
So it's totally separate. So Summa then switched their argument from peer review to doctor-patient privilege. They're no longer arguing, at least in this appeal of peer review. And you'd ask Justice Lanzinger, what about email communication where they admit that they contaminated? They've refused to provide most, if not all of that information under peer review, which is not an issue. But we can't get those emails because they're arguing they're privileged under something separate.
Or you can't even get any content.
Right. So we're left with, all right, well, let's get patient C, let's do our own investigation. Let's figure out where this contamination happened so that we can see if there was negligence.
But we are talking about privilege here. For example, with attorney-client privilege, if you confess to your attorney that you murdered your wife, some information is privileged, and even if it helps your case, you can't get it. So is the trial court's order too broad, I guess is the question.
So there is no evidence in the record that this information was used as communication between a doctor, a dentist, or advanced practice nurse as it falls under the statute, such that it would qualify as doctor-patient privilege communication. As Justice Stevenson recognizes, any statutory privilege must be strictly construed against the party seeking to assert it. They have the burden, and it may be applied only to those circumstances specifically named in the statute. Through the case law, we know that not every communication within a medical record is automatically subject to 2317.02, and that the determination is dependent on two factors. Did the conversation take place between a patient and their doctor, dentist, or nurse, and whether the purpose of the conversation was for the diagnosis or treatment? And we have neither in this case. This barcode information of time and person, who grossed, who embedded, who cut. There is no evidence in the record that this falls under any communication between a doctor and patient C. Zero evidence to support that. And further, no evidence to support that it was for the purpose of conversation for the diagnosis and treatment. I've been doing this for almost 20 years now. I've requested lots of medical records. I've never seen this information, this barcode system until this case. Defendants, or Summa, appellants, they attempt to conflate privileged, which is 2317, with the definition of medical records under 3701. They're very, very different. 2317 falls under court common pleas evidence of the revised code. 3701.74 falls under health, safety, morals, Department of Health. And it defines a medical record, and it says that a patient is entitled to a medical record, and then it discusses the definition of a medical record. Appellant cite Griffith versus Altman Hospital, which Attorney Plackus and I argued roughly in 2005. I'm very aware of it. And it deals with the patient's right to their medical records. that risk management isn't allowed to store medical records in its department, therefore the patient isn't entitled to them. The court in that case, they're entitled to their records regardless of where they're stored. That is very-
Do you dispute in this case whether the information is a medical record? Do you, I know we have other statute over there, and you're telling us to don't apply that statute, we're looking at 2317, but do you dispute that this is a medical record under 17, but 2317, but just not confidential?
I would suggest to this court there's not sufficient evidence in the record that this evidence is a medical record. Because there's no evidence that the time that a specimen in the laboratory was gross is used for purposes of diagnosis and treatment. Zero evidence in the record to support that. So maybe in another case, Your Honor, but certainly not this case. But you are correct in that even if this were a medical record, does not mean that it was doctor-patient privilege.
I have a thought experiment question. The privilege runs with the patient, not the hospital. Have you ever been involved in a case or known of any case law that involves the court compelling the hospital to ask the patient if she would, or he would waive privilege?
I am not. Yeah, and we have, all we know is it's patient C. Patient C had lung cancer. Another thing at issue in this case is whether or not the specimens were gross back-to-back. It is based on Summa's own testimony, like specimens, lung specimens should not be gross back-to-back. The reason is it's more difficult to pick up if there's contamination. If you go from breast tissue to lung tissue and there's contamination, it's easier to pick up. Part of the discovery issue is we've asked whether or not Mariann Cummings and patient C specimens were gross back-to-back. Summa, they switched their objection from peer review to now this is doctor-patient privilege, and they argue that would violate the civil rights of patient C. For us to know yes or no, this is actually a request for admission, admit or deny whether or not Mariann Cummings and patient C's specimens were gross back-to-back, objection, violation of patient C's civil rights. Which goes back to Judge Carr's question, how do we prove negligence if we can't even get that basic information?
So really what you only had left, you've gotten it from other sources basically, so really what you only have left is whether it's back-to-back.
So we are left with, we don't know if it was back-to-back.
Right, I know you don't know when. You know it was that day though.
We
You know
know-
it was the same lab technician.
We know John, so there's different, with the grossing, it's John Coombs. With the embedding and cutting, it's different technologists. So it is figuring out, and if they were gross back-to-back, in addition with the testimony we have about John Coombs, with him being sloppy, not cleaning up his station between specimens, Kathy Pritchard, a former employee of Summa, testifying that he was like a pig. You know, that testimony would help us prove that that's where the contamination happened. And if we can prove that they were gross back-to-back, that he was negligent in grossing patient C and then Mariann Cummings, because it's against policy and frankly it's against common practice as to what you're supposed to be doing when you gross specimens.
We could take you back to the privilege area. You argue that for it to be not privileged under 2317, or to be privileged, have to be a conversation between the patient and the doctor, one way or the other. So let's say a situation, I go in an emergency room, they do a series of tests. Before all the tests come in, the doctor says, you can go home. The doctor never talked to me about one of the tests that are done. Would you say that's not privileged because the doctor never spoke to him about the test?
So the privilege is broad enough, it includes registered nurses. I also think oftentimes, so you will now go to the emergency department, and you're right, you won't see a doctor, because oftentimes there's advanced, they call mid-levels, whether or not it's a PA or an NP. They are being supervised, or physician is usually involved some way, shape, or form with that procedure. So I think there's an argument, a very good argument, that that would fall as a.
So long as one of those people came and said there's a test and everything's fine, that would seem to fit into there. But if no one ever come to talk about the test and as a result, they just say, discharge, or I'm an inpatient person, and say, I'm leaving, I'm going home, and I go home without getting the test results. Would you be telling me that's not privileged in that?
I think it would obviously depend on the facts of the case, but I think there would be an argument that if there was no physician, if there was no nurse involved in the communication in any way, shape, or form, there'd be an argument that would not be privileged information.
And I think it's clear from the record in this case, the information we're talking about was never discussed between the patient and, in this case, patient C and the doctor.
We have zero evidence to support that.
Has this court ever said there is a requirement that there must be communication between the patient and the doctor for I don't recall any
Yeah.
cases citing ninth district cases on it, I guess is my question to you.
Not that I am aware of. We have a lot of decisions out of the 8th that we've cited and we've provided the supplemental authority on involving the same firm. That came out in July, and it held that communication reports and documentation of incidents of abuse and neglect is not protected by doctor-patient privilege. And they're making many of the same arguments that they're making here today. That this blanket doctor-patient privilege prevents all of those reports of abuse and neglect of other patients, and in that case, it's a residential facility of residents from being discovered. So I'm not aware of the 9th, but lots out of the 8 that we have provided to the court. And these sort of cases, they hang their hat on Roe versus Planned Parenthood, which came out of the Supreme Court. In that case, the parties agreed, they stipulated that they were dealing with privileged information, which we are certainly not agreeing with in this case. We even asked in discovery, admit that Mariann Cummings' specimen and patient C were gross within 10 minutes of each other. Trying to find some sort of basis for negligence and to prove our case. And again, they said that they could not answer that request, that violating the civil rights of patient C. One thing that we discussed with the trial court, they use this shield of doctor-patient privilege as to why they can't give us this information. And yet, they have no problem publishing information about patients when it is anonymous, when it's redacted. They're not talking about patient Megan Franzold had this procedure. Instead, it is an anonymous patient presented with these signs and symptoms. These were our findings. They can publish that. They have no problem doing that. And yet, at the same time, when we're trying to prove that this shouldn't have happened, that Mariann Cummings should not have been diagnosed with lung cancer and had a third of her right lung removed, they're saying they're not at fault. We're trying to prove the source of the contamination. They say that's doctor-patient privilege.
And count a little less than a minute time.
So, we suggest that they use it when they want to, but in this case, they're using it as a pretextual shield in attempting to get Mariann Cummings and her family from finding out the truth of what happened. If there are no additional questions, in closing, we ask that you sustain the trial court's December 15th, 2023 ruling and find that the times that a patient's specimen was grossed, embedded, and cut are not privileged as doctor-patient privileged communication. Thank you.
You have 4 minutes for rebuttal, counsel.
Thank you, Your Honor. Judge Stevenson, I want to start at the ending of plaintiff's counsel's argument with your question about what authorities are out there as to this notion of, is everything in a privileged medical record privileged, or are there certain other authorities that would recognize that some information in a medical record may not? To be clear, the courts that Ms. Franz Oldham has referred to, particularly the 8th District in cases like Laparo and Camacho, well, they have held that there may be information in a medical record that is not privileged. The discovery requests in cases like that are not comparable to the one here because they have asked about facility level information, not discovery requests about a specific patient's information. Nothing stops, at least no privileged information, stops plaintiffs from serving discovery about the whereabouts of a particular histologist or lab techs that they're critical of, asking about when they were on duty, where they were, when their card swipes were accessed, things like that. Those wouldn't be medical record privileged information.
So I had a question down that goes along those lines, and that is, so if they presented discovery to you, was there, did any technologist, or you could even say John Coombs, but if you want to go broader, you could say any technologist on that particular date that we're talking about here, do any lung samples back to back? Would you say that is discoverable?
It's the first time I've thought about this question, Your Honor. I don't think it would present a medical record privilege issue. My gut instinct is that that would be comparable to the kind of requests that were made in Laparo, where they're asking about more facility logistical data. Speaking briefly about the medical record issue, I know that Appley indicated that she thinks it's in dispute whether, or it is questionable whether the barcode information here is part of the medical record. The only evidence that I'm aware of in the record before this court on that issue is Robert Stewart's testimony that I referenced before, indicating that yes, the barcode information is stored in the Vantage and LIS systems, which is part of Summa's medical record. Looking just briefly at the statute, 2317.02B5A would seem to address this kind of request on its face when it says that communications include recordings and particularly the medical records. And when we look at what this court has said in the Grove case, it said when you determine what communications means, you have to interpret it broadly and can involve any kind of information, even if it was part of it. Ultimately, what Grove said is when they ask for the medical record itself, let's pretend it's a file, even though we all know it's broader than that. That itself is privileged. Can there be discovery requests that ask information related to that? Then they said, well, let's look what the request is, and let's look at, is it something that was being recorded in the course of a particular patient's treatment? Ultimately, that's the objection here, is that the requests plaintiffs are making are asking Summa to respond to discovery requests with information that must be drawn from a particular patient's medical record. And there's no consent here, there's no applicable statutory exception that they're advocating for. So if this court has other questions, I'm happy to answer them. Otherwise, I thank you for your time, and we ask you that you reverse and vacate the court's discovery order.
Let me ask you the last question that App.No raised, and that is, what is the difference between releasing public information, just statistically, about patients and so forth, if the record isn't, if it's not revealed, because you're still revealing that so many patients had cancer, so many patients had, mastectomies, blah, blah, blah.
Ultimately, I think the difference is, so first off, when you're talking about cases like Lepar and Camacho, or we're talking about still let me write information, it might be produced in a form that's something like, a redacted spreadsheet. Ultimately, the fact that you're talking about redaction, multiple different patients, and facility-wide data would make it much harder to, at least in theory, trace back to a particular patient. Whereas if you're responding to a particular patient, and I recognize that patient C is ultimately proceeding under a pseudonym here, we don't know who it is. I don't know whether Summa's responses would ultimately make that information traceable. I'm not going to tell you that it definitely would, but I do think there's a categorical difference between when you're producing aggregated information and when you're producing information about a specific patient that could, depending on what's in there, make that patient traceable. Thank you, Your Honor.
Thank you, and thank you both of you today for your presentation on behalf of the court. The court will take the matter in advisement, issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of court and also be available in the highest Supreme Court website. So with that, the court now adjourns until Thursday, August 29th at your